right, we ready? Here we go. Here we go. You want to listen to this. Question 1. What is the difference between the way the federal rules of evidence and the New Mexico rules of evidence were adopted? 2. What did the Pope order at the Fourth Lateran Council in 1215 that led to the use in England of the jury to resolve criminal cases? 3. Lord Justice Cook's decision in Bushell's case established what principle fundamental to the modern right to trial by jury? 4. What is the power of jury nullification? 5. What is the power of judicial review? 6. In the original Bill of Rights, Fifth Amendment, identify 2 of the 3 provisions which help strengthen and guarantee the power of the jury as the instrument of the people. 7. In what way did the 14th Amendment differ from all other constitutional amendments which preceded it in terms of the focus of its impact? 8. The primary duty of any prosecutor is to do justice, true or false, circle 1. 9. According to the United States Supreme Court, what is the minimum number of members which a criminal trial jury must consist of? And I give you 4 options, 12, 10, 8, or 6. 10. In a criminal trial, that's the last one, and it really confused everybody. In a criminal trial, what is the primary difference between an opening statement and a closing argument? 11. In the voir dire process, what are the 2 methods by which attorneys evaluate prospective jurors? Attorneys exclude prospective jurors in the veneer from service on the petty jury, which will decide the case. Identify the 3 forms of evidence that may be introduced in any criminal trial. Identify the 2 forms of judicial notice. What is the difference between a presumption and an inference? The use of a presumption in a criminal case can sometimes shift the burden of proof to the defendant, true or false. Under what circumstances may a trial juror be questioned after the verdict is returned about the manner in which the jury conducted its deliberations? 19. When called as a witness to impeach the character of a witness who has previously testified, the character witness may testify in one of 2 forms. What are they? 20. Give 3 examples of impeachment of a witness for bias. 21. If a party cannot establish an unbroken chain of custody of a particular piece of evidence, the consequence is the evidence is not admissible / the evidence is admitted, but the jury is asked to discredit it, circle 1. 22. Concerning the admission and evidence of a document as real evidence, what is the primary question which the sponsoring witness is asked to answer? 23. A computer printout is usually considered an original under the best evidence rule, true or false? 24. Under Rule 702, once the trial judge decides that the proffered expert is properly credentialed in a legitimate field, the testimony may still be excluded unless the opinion is based on 3 considerations. 25. Identify 2 of the 3 limitations on the scope of the privilege against self-incrimination which arise from the language employed by James Madison in the Fifth Amendment in the Bill of Rights. 26. Which of the original reasons for the exclusionary rule do conservatives on the U.S. Supreme Court insist is the only rationale for the rule? 27. What is the no comment rule which applies to all testimonial privileges, including the privilege against self-incrimination? 28. By defining the declarant as a person, Rule 801B excludes from the definition of hearsay testimony about what 2 types of out-of-court incriminating information? 29. Identify 3 of the 5 circumstances under which a declarant is deemed unavailable to testify at trial, making certain kind of reliable hearsay statements admissible under Rule 804A through the testimony of a witness who heard the declarant make the statement. 30. Identify 2 of the 3 kind of reliable hearsay statements which are admissible under Rule 804A when the declarant is unavailable to testify at trial. 31. Identify 2 of the 4 categories of out-of-court statement which Congress by definition established as not hearsay under Rule 801D, even though they meet the general definition of hearsay. 32, why are the rules prohibiting hearsay evidence no barrier to receipt and evidence of the confession of a criminal defendant? 33, what three features of the in-court testimony of any witness, which normally ensure the reliability of that testimony, are missing from most statements made out of court? 34, the prosecution seeks to introduce at trial the grand jury testimony of a witness who has died. Why does the trial judge sustain the defense objection and keep it out? Because it does not meet the criteria for admissible former testimony under Rule 804B. 35, hearsay has traditionally been excluded from evidence because it is regarded as blank, one word. 36, what are the three elements constituting the definition of hearsay? 37, why is the normal ban on hearsay no barrier to use of a prior inconsistent statement to impeach a witness's testimony at trial? 38, identify three of the foundational requirements for the admission of a document under the business records exception of the hearsay rule. 39, the common law prohibition against the admission of hearsay developed in response to the unfair treason trial of what famous Englishman after whom the capital of a U.S. state is named. 40, three different things may constitute a statement for purposes of the hearsay rule. Identify two of these. 41, identify three of the four abilities or capacities of any witness which the jury is evaluating in deciding whether to believe them. 42, identify two differences between an admission and a declaration against interest. 43, identify two of the four foundational requirements to admit prior testimony as an exception to the hearsay rule under Rule 804. 44, why does the law consider statements made to medical personnel for the purpose of diagnosis and treatment to be reliable hearsay? 45, a police report is admissible in a criminal case under the public records exception of the hearsay rule, true or false? 46, identify four of the 10 categories of pretty reliable hearsay admissible under Rule 803, even though the declarant is available to testify as a witness. 47, police officer testifies at a hearing on a motion to suppress evidence in which it is alleged by the defense that the cop violated the Fourth Amendment by making a warrantless entry into the defendant's house. That central dispatch told him that the victim had called to say the defendant had a gun and was threatening to kill her. How do you rule on the defense's hearsay objection to the officer's testimony? Sustained, overruled, circle 1. 48, suppose the judge denies the motion to suppress and the case proceeds to trial at which the victim fails to show up. Can the prosecution introduce the 911 tape in its case in chief over the defendant's objection that it is hearsay and violates his constitutional rights to confront his accuser, yes or no? 40, witness testifies that her friend victim was afraid of the defendant after they broke up. She testifies that victim kept a diary in which she recorded all the defendant's harassing telephone calls, text messages, tweets, and unwanted visits as soon as they occurred. Witness testifies that she's familiar with victim's handwriting and that the diary the prosecutor is showing her was written in victim's hand. The state then seeks to introduce the victim's diary for the days preceding her murder. Why does the judge correctly overrule defendant's hearsay objection? 50, officer testifies that when he reported the scene of the reported domestic fight, victim was hysterical, crying, shaking, flushed face, yelling, "That bastard tried to stab me again." At defendant's trial for assault on a household member, victim fails to appear in defiance of the state's subpoena. When the prosecutor elicits her statements through the testimony of the officer, why does the judge correctly overrule the defendant's hearsay objection? 51, witness is an EMT who was treating victim in an ambulance on the way to the hospital where she subsequently died. May he testify at her alleged killer's trial that she blurted out that the defendant did not stab her, but that it was her brother-in-law? Yes or no, circle 1. 52, Don is injured in an auto accident at the hospital while receiving treatment in the ER. He tells the doctor that he ran the red light. The doctor notes the comment in Don's chart. At the trial of Don's personal injury claim against the other driver, Don successfully objects to the introduction of the chart as a business record, since the matter of his running the red light is not relevant to his obtaining diagnosis and treatment. On what basis is the doctor's testimony nonetheless admissible against Don and not considered hearsay. 53, identify 2 of the 3 most commonly employed means of selecting people for jury duty. 54, for the clergy penitent privilege to apply, the person to whom the confidential communication was made must actually be a member of the clergy and not somebody pretending to be. True or false? 55, which spousal privilege is recognized in the state courts in New Mexico? 56, evidence made inadmissible by the application of a common law testimonial privilege is considered in the law of evidence to be A, immaterial, B, irrelevant, C, incompetent. 57, which is the oldest first recognized common law testimonial privilege? A, has husband-wife, B, priest-penitent, C, doctor-patient, D, attorney-client, E, psychotherapist-patient, F, reporter-source. 58, the main exception to the attorney-client privilege is called the blank fraud exception. 59, the attorney-client privilege protects from enforced disclosure between and made during 60, the attorney-client privilege belongs to the attorney and not the client. True or false? 61, may a corporation claim the attorney-client privilege, yes or no? 62, in a criminal case, when the prosecution proves the existence of certain facts from which the jury may infer other facts, the burden of proof shifts to the defendant to show that those presumed facts are not true. True or false? 63, identify 1 exception to the doctor-patient privilege which would permit the doctor to tell the jury what the defendant told him in the course of his treatment. 64, a defendant charged with murder in a state which recognizes only a spousal incapacity testimonial privilege seeks to prevent his ex-wife from testifying about what he told her in confidence while they were married. May she testify about these conversations, yes or no? Assume the trial is taking place in a state which recognizes a spousal confidential communications privilege. May the subpoenaed ex-wife testify anyway because they are now divorced, yes or no? 65, when one spouse is accused of committing a crime against the other in New Mexico, may the victim's spouse reveal confidential communications which occurred while they were married, yes or no? If the crime charged was against a child of the marriage, may the non-accused spouse be prevented from testifying about the confidential communications by the defendant, yes or no? 66, at John's trial for drug trafficking, the state called as a witness Harry, one of its confidential informants. On cross-examination, Harry refuses to disclose his real name for fear of retaliation by his drug connections. Does the defendant have a right to know the witness's real name in order properly to impeach him and to vindicate his right to be confronted by his accusers, yes or no? 67, may the jury consider as not proven a fact the judge took judicial notice of, yes or no? 68, under what amendments in the Bill of Rights are we all guaranteed trial by jury? 69, under what circumstances at trial is the judge required to take judicial notice? 70, under the common law, there were 6 categories of people who, by virtue of their status, were always considered incompetent to testify as a witness. Identify 4 of these categories. 71, competency of a witness to testify is measured as of the time of the events being testified about and not as of the time of trial. True or false? 72, both incriminating statements and confessions are admissions for purposes of the hearsay rule. True or false? 73, once a witness has testified on direct examination, may the adverse party in cross-examination seek to impeach the integrity of the oath the witness took by inquiring into the witness's belief in God, yes or no? 74, to be relevant under Rule 402, what 2 attributes must any proposed item of evidence possess? 75, with respect to any item of demonstrative evidence, the sponsoring witness must testify that it is a blank and blank representation of what it purports to illustrate. 76, name 3 of the methods to impeach an expert witness. 77, in order to permit any expert witness to testify, the trial judge must first come to believe the expert's opinion is true. I forgot to tell you that that's completely false, so that's the answer. 78, I mean, it doesn't matter what the judge thinks. You know, if it's an appropriate expert in an appropriate field, appropriately credentialed, and it's relevant, then he's allowed to testify. It doesn't matter if the judge believes him or not. 78, another name for the jury instructions read at trial by the judge is the judge's blank to the jury. 79, the larger group of people from which the trial jury is selected is called the blank. 80, what are the two types of tangible evidence? 81, identify two kinds of relevant evidence which are incompetent. 82, does a fraternity have an attorney-client privilege, yes or no? Does a sorority have the right to remain silent? Privilege against self-incrimination, yes or no? Do the fraternity and sorority enjoy a right to counsel under the Sixth Amendment, yes or no? 83, what is the standard of proof the state must meet at a preliminary examination? 84, what is the standard of proof the state must meet before a grand jury may indict someone on suspicion they committed a crime? 85, when a trial lawyer objects to the introduction of an item of evidence, the trial judge makes one of two rulings on the objection. Either the objection is blank, in which case the evidence is admitted, or the objection is blank, in which case the evidence is excluded. 86, identify two primary sources of the law of evidence. 87, when the novel deceased jury was established, why was it made up of 12 men? 88, identify two ways in which the traditional right to trial by jury in criminal cases has been undermined by changes in federal law and policy in reaction to the 9/11 suicide crimes. 89, identify two of the primary functions of criminal courts. 90, under what constitutional amendment is a child born at Memorial Medical Center to parents who are both Mexican citizens from the place of her birth alone a citizen of the United States? 91, identify four differences between the adversarial and the inquisitorial systems for resolving criminal cases. 92, when an unduly suggested pretrial confrontation procedure is used to get a witness to identify a suspect, why is there a danger of irreparable misidentification? And that's it. A lot of repeaters, so you should have no trouble at all.
Can you gather from me?